Get ready. 3 seconds. 2 seconds. Start. The appellant being aggrieved by the judgment and order in WA number 535 of 2001 and other connected appeals, and also the dismissal of review petition number 124 of 2006 by the division bench of High Court of Gauhati is before us in these appeals. The factual matrix in brief is as under. The Union of India had introduced family welfare scheme under its family planning program with effect from the first day of September 1966. Under the said scheme, there was a provision for the appointment of voluntary female attendants on a monthly honorarium of rupees 50 per month from the inception of the scheme, which was subsequently increased to rupees 100 per month with effect from February 2001. According to the Union of India, the work of these attendants is to motivate people in their locality to have a small family. This assertion of the Union of India is disputed by the private respondents. They assert that though they were appointed as volunteers, they were made to assist the auxiliary nurses cum midwives in the health subcenters at the time of field visit and for miscellaneous works like cleaning, etc. in the subcenters. Unfortunately, the text of this judgment of the learned single judge is not before us for our perusal, as the counsel appearing on both sides have stated that though they have made all efforts in to secure a certified copy of the judgment, they have been unsuccessful, as the same is not available in the registry of the High Court of Gauhati. Therefore, we will have to proceed without having the advantage of seeing the reasoning of the learned judge in his conclusion. However, in the subsequent judgment passed by the High Court, there is some reference to the findings and conclusion reached by the learned single judge in Nandeswari case. This may help us in understanding the reasoning and conclusion reached in the Nandeswari case. After the decision of the High Court in Nandeswari case in CR number 3847 of 1993, nearby 54 voluntary female attendants filed writ petition in the High Court inter alia seeking the same relief that was granted in Nandeswari case. The lead case was filed by the Brahma, being CR number 3073 of the 1995. The relief that was sought in the writ petition was for regularization of their services and for payment of salary as per the existing pay scale. In the light of the decision of the court in Nandeswari case, the learned single judge of the High Court by judgment and order dated 22/2/2000 partly allowed the writ petition and directed all the respondents to pay rupees 900 per month, the minimum of the pay scale to the voluntary female attendants. In view of the above, we allow this appeal and set aside the impugned judgment and orders passed by the division bench of the Gauhati High Court and remand the matter to the High Court with a request to dispose of the appeals as early as possible, at any rate within 6 months from today, after ensuring that proper parties are implicated. During the interregnum, we direct the state government to pay the minimum wages under the provisions of the Minimum Wages Act as notified in their official gazette to the private respondents. Liberty is reserved to all the parties to raise all such contentions which are available to them, including the contentions raised before this court. In the facts and circumstances of the case, we direct the parties to bear their own costs. Having considered the rival opinions suggested by the learned counsel for the parties to the lies, and also keeping in view the interim orders passed by this court dated 24/2009, pursuant to which it is the state of Assam which is paying minimum of pay scale to the private respondents. We are of the view that the private respondents in these appeals require to be paid at least minimum wages payable under the Minimum Wages Act during the pendency of the appeals before the High Court by the state of Assam, subject to the final orders